All right. Good morning. I'm Sam Bivens. And actually, let me do an audio check. Can everyone hear me okay?
Yes.
Right. So as I said, I'm Sam Bivens. I'm a hearing officer with the State Water Resources Control Board's Administrative Hearings Office. This is the public hearing on the proposed cease and desist order against David Collenberg for diversions reported under water right IDs S000774 and S019640, issued by the State Water Resources Control Board's Division of Water Rights on April 26, 2024. During this proceeding, I'm going to refer to the administrative hearing document, EHO. This hearing is being held in accordance with the amended notice of public hearing issued by the AHO on July 12th, 2024. We're conducting this hearing by Zoom web conference and live streaming the hearing on the AHO YouTube channel. Staff from our office are recording the audio and video and will post files of this recording along with the Zoom generated transcript to the AHO FTP site. The YouTube recording will also be available on the AHO YouTube webpage. If at any time you experience technical difficulties trying to communicate with us, please send an email to the AHO at adminhrgoffice@waterboards.ca.gov. AHO staff will be monitoring the box during the hearing. Assisting me today are several staff of the Administrative Hearings Office, Rebecca Stolfus, Kyle Woolbridge, and Skylar Anderson. Ms. Stolfus from our office will handle the screen sharing of exhibits. Witnesses and attorneys may simply ask Ms. Stolfus directly to share and navigate exhibits. If at any time I'm experiencing technical difficulties during this hearing and I'm not able to rejoin the Zoom conference within a few minutes, one of my staff will call a recess until I'm able to rejoin. With preliminaries out of the way, let's move to appearances. To do that, I'll identify the two parties that appeared at the pre-hearing conference. And if you are representing those persons or entities today, please unmute your microphone and identify yourself. Please also introduce anyone else from your party that's on the call this morning. So for the State Water Board's Office of Enforcement Prosecution Team.
Good morning, Mr. Bivens. My name is Debbie Orrs, and I'm here representing the Division of Water Rights Prosecution Team. Ken
Petrozelli, also from the Office of Enforcement. I will be assisting Ms. Orrs today.
Very good. It looks like we have a number of other folks from the division as well. Ms. Orrs, would you mind introducing those folks?
Sure. We have with us from the Division of Water Rights, Ms. Menai, who will be testifying today. We also have Mr. Robert Cervantes, who is the program manager of the enforcement section, and Mr. Sahil Pathak, who is a Ms. Nai's supervisor and also has a lot of knowledge of this proceeding.
Very good. And I'm going to try to project a little more since at least one person on my team says I'm getting a little quiet. So I'll try to be a little louder. And David Collenberg. Mr. Collenberg, if you're here, you need to come off mute, please.
Yeah, I'm here.
Good morning, Mr. Collenberg. Mr. Petrozelli, you had your hand raised for a second. Have I missed anyone?
Yeah, yes, Mr. Bivens, you commented on your audio. It maybe sounds like a microphone issue.
Let's see if I can try the headphones. Give me 1 second. I have the microphone built in. All right, how's that?
Good so far. Thank you.
Excellent, thank you. All right, before we begin today, I wanted to lay out my understanding of what this hearing is about and invite any comments from the attorneys to the extent necessary, or from Mr. Collenberg. So as identified in the amended notice of public hearing, the purpose of this hearing is to receive evidence and arguments relevant to the following hearing issues. One, is respondent required to install and maintain a measuring device or employ a method of measurement in accordance with the California Code of Regulations, Title 23, Section 932? If so, what are the requirements with which respondent must comply under California Code of Regulations, Title 23, Sections 933 through 938? Two, has respondent complied with his obligations, if any, to measure and report his diversions under California Code of Regulations, Title 23, Sections 932 through 937? And three, if respondent has not complied with his obligations under California Code of Regulations, Title 23, Sections 932 through 937, what relief should be granted? So with that, I will turn to Ms. Orrs to make the prosecution team's opening statement, and then we can move from there to swearing in your witness. So Ms. Orrs, please go ahead and make your opening statement if you'd like, and then we'll swear in Ms. Nye.
Thank you. Good morning, Mr. Bivens. We are here today because respondent David Collenberg has failed to install water measurement devices at his 2 points of diversion as required by the measurement and monitoring regulation. For more than 2 years now, the Division of Water Rights has attempted to work with the respondent to aid compliance. But despite this prolonged and continued outreach, the respondent has made no measurable progress towards compliance. In fact, he's repeatedly ignored efforts by the division to discuss the measurement and monitoring requirements, and it was only upon the receipt of the draft cease and desist order that the respondent was forced to acknowledge the alleged violation. Since then, his claimed efforts towards compliance have been nothing more than performative. The prosecution team witness, Ms. Me and I, will detail the division's attempt to work with the respondent and the efforts that have led to this proceeding. As you previously mentioned, the hearing issues ask whether the respondent is required to have measurement devices installed at his points of diversion, and if so, does he have such devices installed? Through Ms. Nye's testimony and the prosecution team's evidence, we will show that the respondent is clearly subject to the measurement and monitoring regulation and has not only failed to install compliant devices, but has made sustained efforts to avoid the installation of devices that would require him to report on actual rather than estimated diversion amounts. Further, we stand by the requested remedy of the cessation of diversions until the respondent comes into compliance with the measurement and monitoring regulation. The respondent has a history of 1, non-compliance with State Water Board regulations, 2, ignoring or actively avoiding State Water Board communications, and 3, failure to pay penalties levied against him. The respondent has had more than ample time to install compliant devices, and any further delays endangers the health and safety of the Scott River watershed, as well as the State Water Board's effective management of the watershed. This concludes my opening statement.
Thank you, Ms. Orns. And with that, I'd like to swear in your witness. So, Ms. Nye, do you swear or affirm under the penalty of perjury that the testimony you will give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Ms. Orrs, you may proceed with your witness.
Thank you. Ms. Nye, you can begin your presentation.
Okay.
Oh, I'm sorry. Before we do that, we need to affirm that the written testimony she submitted is her written testimony. Can you go ahead and establish that, Ms. Orrs, and then we can move forward.
Ms. Nye, is the written testimony your written testimony? Did you prepare this on your own?
Yes.
Is that sufficient, Mr. Bivens?
That'll do it. Thank you.
Could we call up Ms. Nye's PowerPoint presentation? It's PT3.
Good morning, Mr. Bivens. My name is Mi Nai, and I'm an environmental scientist for the Division of Water Rights Enforcement Section. Today, I will be testifying regarding the draft cease and desist order against Mr. David Collenberg for violations of the State Water Board's measurement and reporting regulation. Next slide, please. To understand the basis of the draft cease and desist order, it's important to know about Senate Bill 88, SB 88 for short. In June 2015, Governor Brown Jr. signed SB 88 into law. This legislation establishes measurement requirements for water right holders and claimants in California. Following this, the State Water Board adopted regulation to implement these requirements. Next slide, please. Now let's look at how these requirements as they specifically apply to the respondent in this case. The respondent is the primary owner of statement S00774 and S019640. Under SB 88, riparian and pre-1914 appropriated claims must measure and report their diversions if they exceed 10 acre-feet annually. Next slide, please. In 2023, the respondent reported a diversion to storage of 1,350 acre-feet for a statement ending in 774 and 440 acre-feet for statement ending in 640. Based on these reported diversions, the respondent is required to install measuring devices capable of hourly measurements. Additionally, the respondent must include these measurements in their annual reports and provide the data to the division upon request. Next slide, please. To provide context for why the prosecution team is proposing a cease and desist order against the respondent, it's important to understand the respondent's history with enforcement actions. The respondent has a history of noncompliance with water regulation. He has received multiple administrative civil liability complaints, ACLCs for short, for failing to file the required annual reports from 2016 to 2018. In 2022, an information order was issued to request data of the respondent's surface and groundwater diversions and usage measurements to assess compliance with curtailments associated with emergency regulation, which was disregarded. This led to an ACLC and subsequently an administrative civil liability order in 2023 for failure to respond, with the associated penalty still remain unpaid. These past and present actions highlight a persistent refusal to comply with water laws and regulations. Next slide, please. Moving on to the investigation into the current violation, in September 2022, division staff issued the respondent a notice of violation for curtailment and SB 88 violations. The respondent replied via email regarding the curtailment issues, stating that he diverted water to storage before the curtailment and used the stored water for irrigation, but he did not address the measuring regulation violation. Next slide, please. In March 2024, the division instructed the respondent to contact staff immediately to resolve the measurement device compliance issue. Although the respondent did reply to the notice of potential violation, stating that he does not divert water into the pond mentioned in the notice, he again failed to address the question about his measuring devices. The respondent has consistently ignored communication from the division. Next slide, please. A cease and desist order is recommended because under Title 23, Section 932, Part C, the required measuring devices should have been installed by January 1st, 2017. Despite the staff ongoing communication and extensive outreach regarding the installation of measuring devices, the respondent showed continuing disengagement. This persistent non-compliance obstructs fair and effective curtailments due to lack of critical information. Given the respondent's track record of non-compliance, it is likely that this pattern will persist unless enforced corrective measures are implemented. Next slide, please. The draft cease and desist order has outlined specific requirements. First, the respondent must cease all water diversions until the required measurement devices are installed. Once the devices are installed, the respondent must submit a report on installed measuring devices along with the annual water use report to the State Water Board. Lastly, the respondent is also required to maintain records of all water diversions from Orofino and Crater Creek and must provide these records upon request. In conclusion, enforcement in this case is critical to uphold the integrity of California water regulation and ensure equitable water distribution. The prosecution team has spent over 2 years trying to get Mr. Collenberg in compliance with the measurement regulations, offering ample time to install measuring devices and compliance assistance. The respondent's failure to comply with SB 88 measurements and reporting requirements impair the State Water Board's ability to manage water resources effectively, particularly in the drought-sensitive Scott River watershed. Without accurate data on water diversions, it is impossible to assess compliance with curtailment order or protect essential ecological resources like salmons. The cease and desist order is necessary to compel compliance, ensuring accountability and protect public trust resources. Continued violations without enforcement would undermine statewide water management efforts. That includes my testimony. Thank you for your attention.
Thank you, Ms. Nye. Before we move to cross-examination, I have a couple of questions of my own for you.
Okay.
So I think on slide 4, you mentioned that respondent diverted over 1,000, reported diverting over 1,000 acre-feet of water to storage. And I'm curious, does his claimed water right allow for diversion of water to storage?
Yes, one of his statement allow him to.
Okay, very good. And then you mentioned that there were multiple administrative civil liability complaints issued for failure to file reports from 2016 through 2018. And did those ultimately go to a hearing? Were they paid? Were they withdrawn? What's the status of those ACLs? And I know there's one from 2022 or 23 that hasn't been paid, but can you tell me what the status of the ACLs for 2016 through 18 is?
I am not aware of that.
Okay, thank you. All right, with that, that concludes my questions. Are there any members of my team who have questions for Ms. Nye before we move to cross-examination?
I do not have any questions.
Right, thank you, Mr. Anderson. All right, so let's move to cross-examination. Mr. Collenberg, you have up to 60, I'm sorry, did someone want to say something? Whoever that is should go on mute, please. So Mr. Collenberg, you have up to 60 minutes to cross-examine the witnesses who have just testified. Do you have any questions on cross-examination for Ms. Nye?
I have questions, yes.
You may proceed.
So my question is this is all addressed to David Collenberg? It's not addressed to David A. Collenberg or David H. Collenberg, which are both beneficiaries of this ranch. And this ranch is not owned by David Collenberg or David H. Collenberg. It's owned by a trust. So I'm not sure why me personally, one of the beneficiaries is being targeted versus the entire trust.
So, Mr. Collenberg, you need to direct a question to Ms. Nye. Not the time for legal argument.
So I need to direct my question to her specifically?
Yes, to the witness.
Okay, Ms. Nye, are you aware that I am not the sole owner of this property? There's multiple owners?
This is not related to my testimony.
That's okay. He's not limited on cross-examination to the scope of your direct. So if you know the answer, you can answer.
Okay. I am not aware.
Okay, so that you're not aware that the property is owned by a trust and not by me personally?
Your name is on the statement.
Yes, my name, David Collenberg is on the statement, correct?
Yes.
There's no David A. Collenberg?
No.
There's no David
Nope.
H. Collenberg?
No, not that I know of.
And there's no revocable trust?
No. We go off of the primary owner on the statements that were submitted to us.
Directed towards David Collenberg, and David Collenberg could be a 7-year-old. It's
Mr. Collenberg, you can't engage in legal argument at this point. If you have a question for Ms. Nye, please go ahead and ask it. Do you have any further questions on cross-examination?
yes, give me one alone. So Ms. Nye, how does legal enforcement take place when the water right holder is not the accurate on these statements?
Well, I'm not aware of that. This is not specific to our case.
So you're expecting me to have a measuring device on something that is not solely mine, that is not owned by me personally?
The requirements are for the property and the versions.
So, Ms. Nye, in 2022, when this property was solely in my name and I was the owner, did you do a site visit?
We did.
At that time of that site visit, did you find me out of compliance?
Not during the inspection.
So
not during the inspection of 2022, you did not find me out of compliance.
And I'm sorry, let's clarify, Mr. Collenberg, out of compliance with what?
With any of this. At that site visit, was I in compliance?
During the inspection, we only inspected for curtailment violation, and we did not find any curtailment violation during that specific visit.
2nd of 2022 that says notice of violation to comply with curtailment and diversion measurements. But at the site visit prior to that, you found me in compliance.
But we also documented your irrigation was on during the curtailments before and after our visit.
Correct, because
As
when you
yes.
I'm sorry, Mr. Collenberg, let Ms. Nye
Sorry.
finish her answer to your question.
Yeah, as shown in PT6, we have photos of the active irrigation during curtailments.
correct, because I was watering from storage.
Mr. Collenberg, you need to ask questions.
So
We'll have an-
did I, when you were on site, did I show you the stored water and you guys said that that was okay for me to continue using?
Yes.
So then how would I be out of compliance if you saw the stored water and said that I could use it for watering, but said that you took pictures and I was out of compliance?
I'm sorry, but I'm going to need to object to this line of questioning on the basis of relevance. This proceeding is about the measurement devices, not about the curtailment order violations.
Sustained. Mr. Collenberg, you need to move on.
Okay, so where I'm getting at is Ms. Nye, when you were here, you said, everybody on site said that I was in compliance. Correct.
Yes, with the curtailment. Also, we did not state anything during the inspection.
Correct. So during the inspection, you never said anything about a diversion measuring device. Correct?
Yes.
So if this was supposed to happen in 2017, how would I be in compliance on in 2022 and you say that I was in compliance, but then now I'm not in compliance? But it was supposed to be in compliance prior to.
I think you're confused between the curtailment violation and SB 88 violation. Those are two separate violations.
Okay, but you sent a letter on September 2nd that addresses both those violations as one on the same
No.
thing. Yes.
They're separate violations. We address both on one letter. That doesn't mean they're the same violation.
One second.
And while Mr. Collenberg is collecting her thoughts, let me ask you, Ms. Nye, is that, I think he's referring to a September 2nd letter. Was that submitted as an exhibit?
It is. It's PT6.
Okay, I'm back. So on September 22nd, and you did the site visit, you found no violations and I was in compliance, correct?
Objection, clarity. What a violation are you asking about?
I said, in the
Sustained.
beginning, I
Hang on,
said,
Mr. Collenberg. Hang on, Mr. Collenberg. You need
Sorry.
to wait so I can rule on her objection. And the objection is sustained. So if you could clarify your question, please.
in compliance in general, I was not out of compliance in any way on that site visit.
Again, there's an objection on clarity. There's many things that Mr. Collenberg could have been in compliance or out of compliance on for a number of reasons,
Okay.
not just from
Hang on.
the site visit.
Well, I believe he said in any way, so overruled. And Ms. Nye, you can clarify your answer as you see fit.
We did not make the determination just based on our visit. We also came back and did our own investigation into his reports, and we found violations.
So you did a site visit, found no violations, and then came back and at a later date and found violations?
We did not make any determination of violation or not based on just the visit. We had to do more deeper investigation.
So when I first asked the question, you said because you said that there was no violations because you told me that in person, correct? On site that there was no violations.
No, we did not make any determination on site. That's one of the procedure that we usually follow.
Okay, since that site visit of 2022 to 2024, did you contact me prior to this notice of cease and desist about a measuring device?
Yes.
On what date?
March of 2024, we sent an email. Let's see. It should be in one of the exhibit.
Okay, so you're saying from 2022 to March of 2024, that's when you sent me the email?
Yes.
So there was no enforcement letters, no anything between 2022 and 2024?
There were other orders that we sent to you that were also ignored.
So, Naive, in 2022, did you email me about my diversion and about the water being low? And me and you communicated numerous times back and forth about, and you asked me if I would turn my diversion off for different weekends to try to help the water, and I complied and agreed, and we communicated numerous times about that.
I'm not aware of that. I don't think that was us that you communicated with.
So did Ms. Naeed, the beginning of this year, when I was still the sole owner of this property, I communicated with you that I was in financial distress, and that's why I didn't put in a water meter?
Mr. Bivens, yes, the respondent sent us some screenshots, but it didn't include any verifiable information such as names and address. So we could not make any determination from those submissions.
So I sent you a copy of my bank statement that showed that I was overdrawn $2,435.17.
It is not verifiable. We cannot make any determination from that.
But that was communicated, right? That I was in financial distress, and I did send something that I was overdrawn on my bank account.
Again, it's not verifiable, and we also
But
sent you multiple funding opportunities to help with the cost.
was that communicated that that wasn't verifiable?
We were willing to work with you.
But I'm asking, was it communicated that it wasn't verifiable?
Let me interject here before we continue down this line. Ms., and this is for Ms. Orrs or Mr. Petrozelli, is there a financial hardship exemption of any kind for compliance with the measurement
Yes, I
regulation?
mean, there is financial hardship, well, it's not an exception. You would still need to then submit an ACP. However, there is a number of other factors than just a bank account statement that is unverifiable. We don't know if he has other bank accounts. We don't know if he has other assets that he can sell. And an ACP is an alternative compliance plan. There is a process, and it is explained on the website. It is explained in the materials that Ms. Nye has sent Mr. Collenberg.
Okay, I understood, Ms. Orrs. I just wanted to make sure we were not delving into irrelevant questions, and I'm satisfied that Mr. Collenberg can continue down this line if he chooses. Go ahead, Mr. Collenberg.
Okay. So none of that was communicated with me, correct?
Objection, clarity.
Sustain. Mr. Collenberg, try and rephrase your question to be more specific.
So none of that information was communicated with me prior to the cease and desist order.
And Mr. Collenberg, let me help you. Information about what?
Any of the financial hardship.
Go ahead, Ms. Nye.
Sorry, I do not understand the question.
Was any of the financial hardship information communicated to me prior to the cease and desist letter?
No, since we're not obligated to provide that until you get in contact with us first.
I sent you an email stating that I was in a financial hardship with a statement showing my financial hardship, correct?
That came after the draft cease and desist order.
Give me 1 second. So you're admitting that I did communicate that I was in financial hardship at that time?
Yes, but it's not verifiable.
At that time, did you request something verifiable from what I sent?
No, we didn't.
So how would I be aware to send something verifiable?
Mm, it was difficult to get in touch with you in the most part. So you also stated that you were willing to work with us to install meters. So we were going toward that route.
So you were unable to respond to that email where I sent the bank statement that that was unverifiable?
Doing that,
Sorry, Ms. Orrs, can you try again?
Asked and answered. I think we've gone on with this bank statement and asking whether or not anybody responded to it numerous times. So
Sustained. Yeah, sustained. Mr. Collenberg, let's move on, please. I understand your point. And Mr. Collenberg, you are on mute if you have additional questions for Ms. Nye.
Yes, give me 1 second. Ms. Nye, on August 28th, did I send you a email showing the diversion was off and the measuring device I was working to get?
objection, this was
Yes.
within the bounds of a confidential settlement negotiation. His
Sustained.
response was in response to our sentence.
Sustained. Mr. Collenberg, you can't just generally discuss the substance of settlement communications between you and the prosecution team. So you're welcome to establish that a settlement communication occurred, but neither Ms. Nye nor you can discuss the substance.
Okay, Ms. Nye, so did I communicate that I was working to get a measuring device?
yes.
And did I communicate that it was going to be after the date of the settlement offer?
Again, this is still within the bounds, objection, this is still within the bounds of the confidential settlement process.
Sustained.
Ms. Naya, so I communicated that I was willing to work with the water board, correct?
Yes.
Ms. Naya, I communicated and allowed you guys to do a site visit on my property, correct?
In 2022?
Yes.
Yes.
Measuring device.
So I communicated with you guys prior to any settlement on a Zoom meeting to work out this situation in 2024, correct?
Yes.
And I attempted to show evidence of financial hardship, correct?
It's not verifiable.
But I
And
attempted.
Mr. Collenberg, we've I think exhausted the financial hardship line of questioning. So let's move on, please.
It's basically about communication. It's not about whether that was hardship or not. It was just communicating it.
I understand that, and I understand where you're going, and I've heard your questions on that line and Ms. Nye's responses. So I understand. Let's move on.
Ms. Nye, so in your statement, you claim that I don't communicate with the water board, correct? Or I'm hard to communicate with?
Yes.
So with the communications that I just referred to, does that show that I've communicated with you versus not communicated with you like you stated?
Objection, clarity.
Sustained. Try and break that up, please, Mr. Collenberg.
So the trail of evidence of communications shows inconsistency with your statement that I didn't communicate, correct?
No.
So the trail of communications doesn't show a trail of communications, is that what you're stating?
I'm sorry. Objection, vague.
Sustained.
So my communications from 2022, 2023, and 2024 don't show communicating with you?
I don't understand the question.
Are emails communication?
Yes.
So is the statement true that I communicated with you in 2022, in 2023, and in 2024?
Objection misstates the witness's testimony. She never said that we did not communicate with him. It was just that he was hard to communicate with.
Understood, but overruled. You can answer that question, Ms.
In my testimony, we stated that he did respond to some of our orders, but he did not fully respond or did not address the SB 88 violations.
Mr. Collenberg, do you have additional questions for the witness?
Yeah, sorry, I'm going through paperwork statements. Have you received proof of service on this matter?
Objection vague. What's this matter?
Sustained. Mr. Collenberg,
Have
please.
you, sorry, have you received a service on this cease and desist order? Proof of service.
Yes, we have a couple confirmation of delivery for multiple documents that were served to Mr. Collenberg, since sending certified mail were ignored and sent back to us. So we had to resort to different means to get important documents to him.
Do you have any proof of service that I personally was ever served?
We have delivery confirmation in the exhibits.
And Mr. Collenberg, you filed a request for a hearing, so I believe to do that, you must have received the draft CDO. So I'm not sure where we're going with this.
I'm just gathering all the inconsistencies in the statements being made.
Well, that's not going to be, in terms of actually receiving service of the draft CDO, that's not going to be a productive line of questioning. So let's move on.
I have no further questions.
All right, thank you, Mr. Collenberg. With that, Ms. Orrs, do you have any redirect questions for Ms. Nye?
I do.
Please proceed.
Ms. Nye, who is responsible for ensuring that the information on the water diversion and use statements is accurate?
The diverter.
And can we pull up PT 18? Ms. Nye, can you read who the primary owner is on this statement?
David Collenberg.
And is there a middle initial there?
No.
And what is it clear that, or is it true that the diverter would be the one to have written who the primary owner is?
Yes.
Thank you. Okay. Next. Is the respondent's point of diversion? We can close this, the PT18. Is the respondent's point of diversion visible from a public location?
Mm, I don't think so.
So would you need to would you have to go upon his property or someone else's property in order to see that either point of diversion?
Yes.
So would that require so you mentioned earlier it's been mentioned earlier that there was a consent inspection. What is required from us to get a consent inspection? Us being the State Water Board?
I don't understand the question.
Do you have to provide prior notice before a consent inspection?
Yes.
How much time do we have to provide? How much time does the division have to provide the diverter prior to a consent inspection?
I'm not sure, but at least we usually provide it at least a couple of days before.
Based on your experience during consent inspections, sorry, just let me think about how I want to phrase this. What is your experience with how water right holders respond to consent inspections in terms of preparing for them?
Please rephrase it.
No worries. I'll just move on.
Okay.
Okay. Speaking of the 2022 curtailment inspection, is it fair to say that the only violation you were there for was the curtailment violation?
Yes.
And how did you determine the measurement and monitoring violations after that inspection?
It was afterwards when we looked into Mr. Collenberg's statements of annual reports, and we found that there was no information about his meters.
And then going to the communications that the division has had, can we pull up PT6 and go to page 2? Ms. Knight, could you read the first two lines of paragraph 3 on this page?
And I'm sorry, Ms.
The div-
Stolfus, hang on one second. Ms. Stolfus, can we zoom in just a hair, please?
Yeah.
All right, thank
Thank you. The Division of Water Rights has reviewed your supplemental statement of water diversion and use and found that you have failed to submit information regarding your measuring device.
And
This failure, yeah,
oh, can you read the date that's up in the upper right-hand corner?
is September 6th, 2022.
Wonderful. And then can we go to PT9? So let's start first. Do you recognize this document? Can you read the
Yes.
date on this document?
It's January 6th, 2023.
Great. And then can we go to page 7 of the document? Paragraph C. Ms. Knight, can you read that paragraph aloud?
Paragraph C.
Yes.
On September 2nd, 2022, the Division of Water Rights issued a notice of violation to the diverter via email with the subject line Notice of Violation for Failure to Comply with Curtailment Orders and SB 88. The diverter responded to that email the same day. The diverter was therefore aware of the division enforcement staff believed that he was violating an order of the State Water Board.
Great, thank you. And then, let's see. Can we go to PT11? Looking at your response, Ms. Knight, can you read the date that the email was sent?
March 15, 2024.
Great. Can you read the third paragraph of your email?
Mm-hmm. In September 2022, we sent you a notice of violation with the notice of violation attached to the email, indicating that you had not installed a flow measuring device required by regulation. You have not filed your 2023 annual water use report, and our records currently show you still have no measuring device installed.
Did Mr. Collenberg respond regarding the SB 88 violation after that email?
No.
Before the CDO? Thank you. Then within the same document, let's see. We can also go to page 8. Ms. Knight, do you recognize this email?
Yes. Can you make it
What was
bigger? Sorry.
Can you see the,
Thank
can you
you.
read the date?
May 31st, 2024.
And generally, what was the intent of sending this email?
It was just to conclude or to give him a summary of our conversation with him and to provide more information for SB 88 and for funding opportunities, as you can see in the link that was attached to the email.
Thank you. And finally, can we go to page 14? Ms. Nye, do you recognize this document?
Yes.
Well, when was this sent and when was this sent? Do you remember?
It was sent along with the same email from May 31st.
Great. Was there a call with the respondent on May 31st?
Yes.
What was discussed during that call?
We discussed about we explained to him what the draft CDO require of him, and we also explained to him SB 80 more information about SB 88 and what is required of him. And we also give him guidance on how to get in touch with installers and people that could help him with installing meters.
Thank you. We can close this document. Ms. Nye, when the respondent sent the information about his alleged financial hardship, was there any names on the picture
No,
he sent? A true bank state? What can you describe the picture? What was it a picture of?
it was just it showed the balance, and that is it.
Thank you. See. Could the respondent have reached out to us at any time with his concerns about financial hardship prior to the CDO?
Yes, of course.
Is it fair to say that the division has reached out to him numerous times about this violation?
Yes.
Let's see. Ms. Knight, could you expand upon in your testimony, you state that it was difficult to communicate with the respondent. Can you expand on what you meant by that?
We have sent him multiple orders. After the notice of violation, we sent him an information order to ask for to have more information regarding his diversion to make sure that he was not violating. It was ignored, and we also follow up with an ACOC and then an ACOO to ask for penalties, but all of those were also ignored.
Can we go to PT 13? Ms. Knight, do you recognize this document?
Yes.
Can you explain what this document is?
It's a confirmation of delivery for the draft cease and desist order.
Thank you. One moment, Mr. Bivens. I think that concludes my redirect, Mr. Bivens.
Very good. Mr. Collenberg, I'll exercise my discretion to allow you to ask up to 10 minutes of recross examination questions within the scope of Ms. Orr's redirect questions. Do you have any further questions for Ms. Nye that was in that scope?
Yes, I have a couple questions.
All right, very good. You've got the floor is yours for the next 10 minutes.
Is it possible to pull back up that picture of that delivery notice?
Yes, Ms. Stolfus, can you please bring back up Exhibit PT-13?
That's a right signature.
Ms. Nye, can you read the signature on that?
The sign floor by
Yes, correct.
front door.
Okay, so do you know if this was the front door to my residence?
I don't have to know that.
Well, I assume for proper service, you would need to know if it was delivered to my residence.
That would be a question for the delivery people.
In your prior statement, you claim that you served me numerous times paperwork, correct?
Yes.
But in this, you don't know that that was delivered to my residence or not?
Well, we have a confirmation from our delivery tracking. And it showed that you received it since you requested a hearing.
Mr.
I'm just-
Bivens, may I just real quick? It appears that there's someone else in the room with the respondent, and I just would like to know what the rules are for having unnamed or unannounced parties participating in this proceeding.
Well, I don't know that they are. It sounds like there's a baby in the background. Which,
Yes, he's 7 months old.
Okay.
Yeah.
It was seeming to us that there was someone actually speaking, but the baby
Well,
obviously always appreciated.
And to the extent Mr. Collenberg has his wife or someone else is in the room assisting him with the hearing, he's the one who's appeared. I don't have any issue with how this is going. So thank you. And I'm sympathetic to the child care situation.
Ms. Nye, I was just wondering when front door signing is a valid service.
I do not understand the question.
Do you consider a front door as signing for his service as proof of service?
It doesn't really matter at this point since you received the draft cease and desist order.
Can you pull up that the version reporting paperwork that you had?
Hang on, Mr. Collenberg. So there are 19 exhibits submitted by the prosecution team. They're numbered PT1 through PT19. Are you referring to the statements of diversion and
Yes,
use?
the one for I believe 20.
What are you? And I believe, Azores, correct me if I'm wrong, I believe that's exhibit PT18 and exhibit PT19, correct?
I would need to see it.
Well, we're gonna short circuit this and actually let me help you here. Ms. Nye, our exhibits PT18 and PT19, the 2023 supplemental statements of diversion and use for the water right claims asserted by Mr. Collenberg. One at a
Yes.
time on the screen. So which of those would you?
Just the one that shows the
pull up?
reporting for 2023 that shows the uses.
Well, there's two of them, Mr. Collenberg. You have two water rights statements, 19640, which is a pre-14 claim, and the other one is 000774, which is also a pre-14 claim. Which of those would you like to look at? They both report use.
The 0071 is fine.
Okay, so Ms. Stolfus, can we pull up exhibit PT19, please? And Mr. Collenberg, by my count, you've got 5 minutes of questions left remaining.
Ms. Naeed, do you have the that's the submission form, but do you have the part where it's submitted by who it's submitted by?
I think you could scroll. Is that the only page? Yeah, it showed the name.
Is that my name on there?
No.
I'm trying to understand the relevance of this line of questioning.
Yeah, where are you going with this, Mr. Collenberg?
Well, she stated before that the name at the top was David Collenberg and that I put that there.
Okay, so, but Mr. Collenberg, if we scroll up to the top of the page, Ms. Stolfus, please go ahead and do that on the screen to the top of the first page. It says primary owner David Collenberg. And then on the bottom of the second page, it said the person submitting this form, which is different from, this is not the water right claim, this is just a form that reports diversions for 2023, is an individual named Sam Roby. So where are we going here?
That's it. That's all I wanted to clarify.
Okay.
So Ms. Naeed has,
Yes, for now, yes.
And that happened because we communicated and I made that happen.
Objection, relevance.
Overruled, I'll allow this one question. You can go ahead and answer, Ms. Nye.
Okay, this was a different issue. He got the failure to file notice of violation. That's completely different from SB 88 violation. So I don't see the relevant.
They came on the same notice and we communicated about the same notice that had both things correct.
There were two notices.
But yeah, objection that misstates testimony and misstates the evidence. The notice of violation was about curtailment 88, not failure to file an SB 88.
Yeah, sustained.
Communication purposes.
And Mr. Collenberg, we've run up against your time limit. I think you've got 1 minute left. So the nice answer to Ms. Orrs for recross.
No further questions.
Thank you. All right. At this point, Ms. Orrs, would you like to move the prosecution team's exhibits 1 through 19 into the evidentiary record?
I'm sorry, can I ask a few follow-up questions?
No.
Oh, okay. Then, yes, I would like to offer the prosecution team's evidence in prosecution exhibits into evidence.
All right. Thank you. Mr. Collenberg, any objections to the prosecution team exhibits 1 through 19? Very good. Prosecution team exhibits 1 through 19 are accepted into evidence. We'll take a short 10-minute break, returning at let's make it 10:35 just to keep it round numbers. And then we'll resume with Mr. O.
I have one question real quick. Will this be open to public comment?
Let's talk a little bit about process when we get back from the break. I'll try to explain a little bit more about how this. All right. Thank you, Mr. Collenberg. See you all at 10:35.
Thank you.
All right, Ms. Stolfus, you can go ahead and unpin Ms. Nye. Ms. Nye, thank you for your testimony and for being here today. Really appreciate it.
Thank you.
With that, we're back on the record. Mr. Collenberg, are you here?
Yes.
Very good. I'd like to explain a little bit about how this is going to go, which will, I think, address your question about public comment as well. So first of all, you're going to have the opportunity to make a 5-minute opening statement. You don't have to, but you can. And then also pursuant to Government Code Section 11513B and Section 648.4 of the State Water Board's regulations, you'll have the opportunity to provide up to 30 minutes of oral rebuttal testimony. Again, that's not required, but you're entitled to that opportunity, and we can talk about that in a moment. In lieu of closing arguments today, I've requested closing briefs of no more than 15 pages per party. Those are due on November 1st, 2024. Again, you don't have to provide a closing brief, but you certainly can. And then once those closing briefs are submitted, the AHO will prepare a draft proposed order. We generally have 90 days to do that. Once that proposed order is prepared, it goes to the State Water Board for consideration in open session. And during that State Water Board meeting, when they consider whether to adopt our proposed order, whatever it is, there will be an opportunity for public comment on that day. Does that answer your kind of questions about how this process is going to go? Mr. Collenberg.
Sorry, what was that last part? My kid was crying.
No worries. So sometime within 90 days after November 1st, the AHO will submit a draft proposed order to the State Water Board. They can consider whether to adopt that or not, whatever it is. And they'll make that consideration at a State Water Board meeting in open session, which there will be some opportunity for public comment.
Thank you.
All right. With that, Mr. Collenberg, you have the opportunity to make a 5-minute opening statement. Do you wish to make an opening statement?
Yes, 1 second.
And before we go there,
Sorry, I just want to make a closing statement. So that'll be November 1st, correct?
yes, November 1st, that will be a closing brief, correct? No more than 15 pages.
Thank you.
All right, so no, we'll dispense with the opening statement. And then you also, as I mentioned, under Government Code Section 11513B and 648.4 of the State Board's regulations, I'll give you the opportunity to provide up to 30 minutes of oral rebuttal testimony. So that's testimony that is directly responsive to and rebuts the testimony that Ms. Nye submitted. Do you wish to provide any rebuttal testimony?
Can my wife do it?
Ms. Orrs, Mr. Petrozelli, would you care to comment?
Ms. Orrs, how about you go first?
His wife is not a party, was not named in this complaint or in this enforcement proceeding. So I'm not really sure why it would be acceptable for her to participate. I don't know if Mr. Petrozelli has anything else to add to that.
I mean, neither was Mr. Collenberg's spouse identified as a potential witness.
Let me check something here. Well, so 23 CCR 648.4 F provides that rebuttal testimony generally will not be required in writing or rebuttal testimony exhibits be required to be submitted prior to the start of the hearing. I will admit it feels a little bit irregular to have a new rebuttal witness who is not Mr. Collenberg, who is not a party, but I don't believe there's any particular to the prosecution team, since Mr. Collenberg also wasn't required to provide written testimony in advance or identify himself as a rebuttal witness. So I'm going to allow Mr. Collenberg, if his wife has relevant rebuttal testimony, the prosecution team, can make objections as it sees fit to that. So, Mr. Collenberg, I would like your wife to appear on screen on a separate device, just so we have a clear record. Do you have a device, assuming your wife has relevant rebuttal testimony to provide? Can we make that happen?
Can we do it at the next? Have to be this one.
There is no next hearing, Mr. Collenberg. This is it.
So the closing statement's just a paper closing statement that I mailed to you, correct? That's not a public one.
Correct. You will submit it to the AHO in accordance with the hearing notice, and it's yes on the papers. And it should not provide new evidence, Mr. Collenberg. It can make legal and factual arguments about the evidence in the record.
It's not worth it. We'll just pass.
All right. So Mr. Collenberg has waived his right to provide oral rebuttal testimony. So we will have none of that, and therefore no cross-examination of Mr. Collenberg or any other rebuttal witness. So, all right. I think we are at the end here. So thank you to everyone for participating today. That concludes our hearing. And as I mentioned, in lieu of oral closing statements, I've requested closing briefs of no more than 15 pages per party, due November 1st, 2024 at 11:59 p.m. The AHO will then prepare a draft proposed order. We generally have 90 days to prepare that draft proposed order, but I suspect we'll beat that timeline after November 1st. If anyone has any questions after we adjourn this hearing, the ex-party rules will still be in effect. So please email our office and copy the service list. Ms. Zors, I see that you have come off mute. Did you have a question?
Yeah, I just
or
wanted to
comment?
clarify that the closing briefs, you want the issues to remain within the listed hearing issues that you have in the notice, or is there any other direction on content?
No, just the hearing issues and whatever you think I ought to consider in preparing a proposed order.
Thank you.
What's the address that this gets sent to?
I am going to turn to either Mr. Anderson or Mr. Wooldridge to explain the mechanics of submitting these closed briefs, please. And I believe it's in the hearing notice, Mr. Collenberg.
Thank you.
But Mr. Anderson, can you just briefly explain what Mr. Collenberg will need to do to submit that?
The closing briefs can be submitted electronically, either by emailing your closing brief to the AHO, uploading it to the AHO's FTP site, or you could mail it in. Did you want me to provide you with the mailing address now?
I think that's in the hearing notice, correct, Mr. Anderson?
Yes.
All right, very good. Mr. Collenberg, does that make sense?
Yes, I know what to do, so that works. Thank you.
All right, very good. And Mr. Collenberg, if you do choose to mail that closing brief, please make sure it arrives on November 1st. And with that, I want to thank our witness and everyone else who participated today. I appreciate your courtesy and professionalism. And with that,